Good afternoon, dear listeners. This is Shahid Hussain from Khan Solicitors, and I'm with you for the next hour. The studio hotline is 0142425 That's 0142425 And if you caught the program last week, you will know that this hour is dedicated to legal topics, and it's brought to you by Khan Solicitors. We have a branch in Sheffield and a branch in Bradford, and we are providing this show as a service to the community. If you have any questions, feel free to give us a call or send us a message on WhatsApp. The WhatsApp number is 078855999786, and in this program we're building up from the previous discussions that we've had around immigration requirements, immigration rules, and making provisions for applicants and sponsors to bring people into the UK either by the EA route or as non-EA nationals. We discussed the different types of category of visas and the requirements of visa nationals and non-visa nationals. Today I want to talk about a topic which is really quite popular. Along with applications for visitor visa applications, this discussion today is going to be on a topic that many people are quite interested in, and that's around the topic of family unions, or basically reuniting people who are in other countries to join their family member here in the UK. And I'm sure that that's a topic that's either affected yourself or somebody that you know, family member, friends, people that you know in the community. So stay tuned in, and we're going to discuss this topic and give a general overview of some of the requirements that are needed. Again, as we've stipulated in previous program, we're not here to provide specific legal advice. It's just a generic discussion to help people get a feel of and an idea of what immigration law is all about, and give you perhaps some insight into some terminology and rules and regulations that you perhaps find puzzling. As I've said, you are most welcome to give us a call on 0142425 and the WhatsApp number you can message me on is 0788855998786, and I'm here with you for just under an hour. The first point of consideration for this particular topic is the needs of a person who is based in the UK has to have a specific category before he or she can consider looking at the possibility of bringing a family member over to join them. So the appendix rules of the immigration rules set out 4 different types of people that are able to put in an application or support an application for a family member to join them. So when you are considering whether you can invite somebody over, you need to ask yourself if you belong to one of these 4 categories. And I'm going to list them for you, and perhaps if you've got a pen and paper handy, you could make some notes for yourself and see if that's a starting point for yourself. Well, the first category of the individual who's going to be able to sponsor someone to join them from a country outside of the UK is going to be a British national. Perhaps strikingly obvious, if you're a British national, you're going to be one of the top categories of people who are going to be able to provide a sponsorship for a family member who's living in a different country to come over here and join you. The second category is a person who's not a British national but is settled in the UK. So they've perhaps got leave to remain indefinite leave to remain in the country and they are settled in the UK. They don't have British nationality, but because of their settlement, they are eligible to act as a sponsor to facilitate a person who's a family member to come over and join them. Third category is a person who's been granted leave as a refugee. So you might imagine somebody who's come over here, sought asylum, been granted refugee status, and they've left family members behind. Well, the rules say that they are also able to put in an application to facilitate their family members to come and join them in the UK. And the fourth category of people is a person granted humanitarian protection status to remain in the UK. As I've mentioned from the outset, the person who is based in the UK is referred to as the sponsor, and the person who is looking to come over as a family member to join any one of those four categories is referred to as the applicant, because they're the one who's making the application to come into the UK, and the person who's based in the UK is the one who's facilitating or sponsoring that application. So what I want to do is go through some different types of categories of people that are likely to want to join the person who's based in the UK, and consider what needs to be done, just as an overview to give you some idea, and the type of application they'll be looking to put in to be able to come and join the British national that they're related to. The first category I want to talk about is somebody who's intending to get married to the person who's based in the UK. So that's usually referred to as a fiancé or fiancée. They've got an intention to get married, and they want to perhaps do that in the UK. Now, generally speaking, the rules don't account for people who are already based in the UK. So the person who's wanting to remain in the UK, if they are already in the UK, they don't tend to have an avenue to put an application to remain here as a fiancé or fiancée. But if they apply from outside of the UK, that's the category of application we're looking to apply, as a person who's intending to come to the UK specifically to marry the British citizen or the settled person in the UK. What that application will allow the person to do, if they're granted that, is it gives them 6 months of leave. 6 months leave to remain in the UK, and in that time there's an expectation in that application that they need to do what they've set out to do, which is to get married to the person that sponsored them there. So the rules allow you to come here as a fiancé, as a proposed civil partner or fiancé of somebody settled or a citizen of the UK, and within 6 months they need to make arrangements to get married. Now there is an option after that happens to consider the possibility of extending the stay. For some people that's sufficient. They get their marriage done and they need to go back to their own country, and that's the end of the matter. But for some people, once the marriage is done, they intend to stay longer, and for them they need to consider extension of their leave following their marriage being registered. Whilst this individual is here, if they're granted entry and leave into the UK, they will be prohibited from seeking recourse to public funds, and they'll be prohibited from employment. So that's something worth bearing in mind, and it's obviously something that would make sense if you've expressed the intention to come here simply to get married. The immigration rules wouldn't expect you to be coming here looking for a job, especially at that stage. The next thing we need to move on to is other partners. Where an application is being made by an individual outside of the UK, they need to apply for entry clearance, and once they've been granted entry clearance, they'll be also granted leave if they're successful for a period of up to 30 to 33 months, just around 2.5 years. Again, similar to the fiancé visa category, they won't be permitted to take any public funds, and at that stage, in the initial stages of the fiancé visa, for the 6 months that they're here, they're not permitted to work. But with respect to this other category of partners, meaning civil or marital partners, they do have the option to work within the 30 months that they're granted leave for. After the first 30 months have expired on their application as a civil or spouse application, they will then need to either make a decision to leave the country or to apply for a second extension. First extension. And that would be again for another period of 30 months. So 2.5 months is a period of time that they would be granted leave in their first application, and 2.5 would be the leave they'd be granted in the extension. So that would be a total of 60 months. 60 months, if you've worked it out, would total 5 years, and that would allow them the opportunity to apply for indefinite leave to remain in the UK. So now you need to ask yourself, what category of person does your family member fall into? Are you with somebody that you intend to get married to, in which case you need to consider the option of bringing them over as a fiancé if you want to get the marriage done in the UK. Some people can't travel back to their heritage countries. They can't travel back to India, Pakistan, or Somalia, Yemen, and they would rather have their partner come here. It might be because they've got work commitments and they can't take the time off, in which case the suitable category for them is the fiancé application. For those people who are comfortable in travelling abroad and are able to go to the native country of their proposed partner, they can fly over there and get their marriage registered in that country and return back to the UK. Two halves of the application process in order to get indefinite leave. People always get confused with that. They get confused with the time period, and they get confused with the terminology. Like we discussed last week, the first element of an application is being granted leave to enter. That's getting permission to enter into the UK. And the second part is being granted leave to remain in the UK. And the leave to remain with respect to spousal applications is 2.5 years, and that's usually up to 30 to 33 months, following which your time's up, and before it's expired, you need to make a second application for an extension for another 2.5 years, totaling 5 years. After that point, you get the opportunity to apply for indefinite leave to remain in the UK. You might have heard this process being referred to as the 5-year family route. Now, in some cases, people will say, well, we can't meet the requirements of that application process. They'll say the rules are too difficult for us to meet. And we still have a family though, right? So there could be somebody living in the UK. They don't meet the requirements of that particular application, and they pose the question, well, what do we do if we're not able to meet those requirements? Well, in that case, the immigration rules can be approached through the Article 8 human rights, family rights route, which is known as the 10-year family route. In the case where you're not able to meet the requirements, you have to take the longer route. Instead of the shortcut, you're going the long way around. And this is different in that it requires 4 periods of 30 months. And you can see how that's double the amount of the 5-year family route. It totals 120 months, 10 years, and it requires 4 periods of 30 months as opposed to 2 periods of 30 months. And these periods for both the 5-year route and the 10-year route are referred to as probationary period times. And if you understand what the word probationary means, you can understand what the implication of that is that you're not a settled person until you fulfill the criteria and you fulfill the requirements placed on you throughout that period of time, and you're not able to get naturalization during that period of time. And if you were to make any significant mistakes in that period of time, you could be asked to leave the country. So those are 2 routes that you need to bear in mind. The one is the quicker route, but that's for people who are able to meet the requirements, which we're going to talk about in a little while. And the longer route for people who are not able to meet the requirement, but still are able to clearly demonstrate that they are in a family, often with children, and therefore there is that discretion applied to them. Next category of family member that can join a person who is a British citizen or settled person in the UK is children. An obvious category when considering people who are family members. Children can enter and gain immediate settlement in the UK if they are joining one or more parents already in the UK. A child can apply to join a parent who has limited leave to enter or remain in the UK, as well as a person who's a British citizen. In addition to that, children can, generally speaking, enter the UK under immigration rules on their own. So, for example, if a child was wishing to come to the UK as a student, then the immigration rules allow them to do that. The next category of a family member wishing to join are parents. So if you have a parent who's abroad, is the sole parent with responsibility of a child, or has access rights, they too can apply to join their child who may already be in the UK, and they would be granted leave to enter and be granted leave to remain under immigration rules, provided they meet the requirements of the eligibility. In addition to that, a parent can also be in a different category and switch over, right? So they could be under a category that's expired and they are perhaps asked to leave the country, in which case they're wondering, well, how do I remain in the UK if this category that I'm under has expired? But at the same time, they've got a child that's a British citizen living in the UK. Well, that is an option where you can switch. You can switch category to remain in the UK. A very clear example of this switching is where a person is a spouse who's come over to the UK, married someone, had a child, and the relationship has broken down. Tragically, it happens quite often where people get married, have children, but the relationship breaks down. In that instance, what they're faced with is the possibility that their spousal application is no longer the same circumstances as when they applied. So in which case their leave to remain needs to be altered, and this option of having a child in the UK allows you to switch over. We're going to head into a break now, but if you have any questions, please give us a message on WhatsApp. The number is 07885599786. My name is Shahid Hussain with Khan Solicitors, and we're providing this hour for you to help you gain a good insight into immigration matters. I will be speaking to you straight after this commercial break. Thank you.
Connecting you to your community. This is Aman FM. This is Aman FM. Set me free and make me strong.
Changing Hearts, a programme to inspire, motivate and warm you through and through. Stories of good news, happiness, success and positive change. If you need a pick-me-up, tune in to Iman FM and I'll be right there.
Khan Solicitors, experienced criminal defence lawyers in defending your rights. We can assist you get the best possible outcome if you're involved in any criminal matters, including murder, drug offences, sexual offences including grooming, terrorism, fraud and money laundering. We can provide free advice and assistance 24/7 at the police station. Call us on 0114 258 3399 at 351 Abbeydale Road, Sheffield. Visit us at khansolicitors.com. Over 20 years experience in defending your rights.
अरे शमसुद्दीन भाई यहाँ कहाँ घूम रहे हैं
भैया रोडरम में कोई खाने का अच्छा जगह होगा है
रोडरम में उम्दा और लजीज खानों का वाहिद मरकज चौधरीज ओरिएंट एक्सप्रेस
अरे भैया तो टाइम जाया ना करो जल्दी करो भूख लग रहा है
देर न लाओ आज ही आओ ते फायदा उठाओ
Cater to impress Chowdhury's Orient Express Princess Street Rotherham telephone 01709 555527
हर कोई सज्जन मित्र बोले चौधरीज ओरिएंट दे पैगे रोले कोकड़ पाए दे गोश्त कढ़ाई आके खाओ होले होले
Aziz Catering, the award-winning caterers specialising in weddings, engagement, birthdays, business parties or any other special occasion from 30 to 5,000 people and delivered anywhere in the UK. All starters, main course and desserts freshly cooked to order and you're welcome to taste before you order. Aziz Catering, 1 Whitefield Place, Bradford, BD8 9JB. Call 01274 488874. Aziz Catering, once tried, never forgotten.
At iLet4U, we know that being a landlord can be a frustrating business, but it doesn't have to be. iLet4U can find you tenants in under a week. iLet4U, specialist in selective licensed properties.
अगर आप मकान किराए पे लगाना चाहते हैं तो हमारी खिदमत हासिल करें और घर बैठे किराया पाएं. iLet4U पर हम आपके घर को अपना घर समझकर रेंट पे देते हैं.
Start finding tenants today by contacting iLet4U, 60 Page Hall Road, Sheffield, 0114 327 2020.
मुअज़्ज़म अली शहीद वेलफेयर ट्रस्ट के ज़ेरे एहतमाम जेल में कायम अस्पताल में पिछले 18 सालों से इलाज मुआलजा मुस्तहिक अफराद को फीसबिलिल्लाह फराहम कर रहा है गरीब खानदानों और यतीम बच्चों के लिए माली इमदाद दी जाती है
With your help we can save lives, educate and help reduce poverty.
आप अपनी ज़कात सदका और खैरात ट्रस्ट को देकर इस कार खैर में अपना हिस्सा डालें
For more info call on 0779 251 5561 or visit muslimtrust.org.uk.
إعلان عاجل لسائقي سيارات الأجرة وسيارات الأجرة الخاصة وسيارات هاكني كاريج مستر كومبنسيتر يدفع 2000 جنيه كتعويض لطالبي التعويض لسيارات الأجرة سيارات البرستيج وسيارات الدفع الرباعي بسبب الحوادث التعويض مضمون بنسبة 100% خدمتنا متوفرة طيلة 24 ساعة على 7 أيام اتصل بنا الآن على الهاتف رقم 0114-386-3386 التعويضات تنطبق على سيارات الأجرة فقط كل ذلك وفقا للشروط والأحكام
Equipping the generation towards a cohesive society. This is Iman FM.
Welcome back, listeners. This is Shahid Hussain from Khan Solicitors. I'm with you for this hour. We've just finished half an hour worth of discussion around requirements for applications to bring somebody over as a family member of a British national or a settled person in the UK. If you've tuned in previously, you'll know that this hour from 4 till 5 on Iman FM is dedicated to legal discussions and topics. And for the last 4 weeks, including this week, we've been discussing immigration matters. The studio hotline number is 0114 24 25 200. This show is brought to you by Khan Solicitors. And our WhatsApp contact number here in the studio is 07 88 55 99 786. That's 07 88 55 99 786. You're welcome to send through some messages, comments and queries, and we'll see if we can answer some of those questions. Just before we went to the break, we discussed various categories of people that you could bring over as family members into the UK. The first category we spoke about was fiancé and fiancée, or proposed civil partners. With respect to that, we said that the application would grant entry and leave to remain in the UK for 6 months, and it necessitated the marriage taking place within those 6 months. The next category we talked about was the category of a spouse or a civil partner, with the prior arrangement taking place prior to the application, meaning that the marriage or the civil partnership has already been established. So the British national, the settled person, is already married to somebody, and they want to invite them here to the UK. The third category of people we spoke about were children. So children of people who are British nationals wanting to join them here in the UK. We stated that they are able to apply and enter the UK, and they're able to get immediate settlement provided they meet the requirements of the immigration rules. And it would be the case where they are joining somebody who is one or more of their parents already in the UK. And just before we went to the break, we touched upon the category of parents, and we talked about parents who are abroad coming here to join their children. But we also spoke about categories of people who are parents that are living in the UK, and they possibly want to switch their visa category, right? And one of the examples I gave, and sadly it's one that we see too often, is when people are here in the country as a spouse. It could be a male or a female, and very sadly and unfortunately their relationship has broken down. Many people come and ask us that question. You know, I came here as a spouse and our relationship hasn't worked out. We are not functioning anymore. We are separated, or we intend to get divorced. We intend to end the marriage, end the relationship, or we've already ended it. I'm now looking at the prospect that my leave to remain has been ended or curtailed, and I'm being asked to leave the UK, or it might be prior to any indication that they've got that the leave has been curtailed, but they've been asked to reconsider their option, because when you come here as a spouse, then you come under that category, right? So people pose the question, well, I've got children here, and if I leave the UK, I'm going to be faced with the possibility of not seeing them for months, if not years. What can I do about that? Well, as we mentioned before we went into the break, that the immigration rules allow you, in a situation where your relationship is broken down, your marriage is broken down, to switch category, in particular if you have a child here. There is a lengthy process in that application and what you need to prove, but we're only here to give you an overview. And the overview is this, that you can consider that as a possibility. Right, so moving on to the next category. The next category we have in front of us is adult dependents. So we are now looking at a British national or a settled person who has a non-EA adult dependent relative who's living in another country, right? And you are looking to have them join you here in the UK. Well, let me give you the 4 different main categories of these adults that could possibly apply to gain entry and leave to remain in the UK as your family member. First category is somebody who is dependent on you as a consequence of their age. So, you know, you can imagine that they're quite elderly, they're infirm, and they don't have anybody to look after them. I think it's a culturally positive trait that many people have in different societies, where elderly people, instead of being put into perhaps an option of being placed in a home, they are taken care of by their immediate family members, their children, or even their grandchildren. It's a positive trait. It's a good thing. But as a result of their age, they are dependent on their family member who's in the UK. They are able to put in an application to gain leave to enter and remain in the UK. The second category, not too dissimilar from the first category, is somebody who is suffering from an illness, and as a result they are dependent on a relative who's a British citizen or settled person in the UK. They too are able to look at putting an application to enter and gain leave to remain in the UK. Third category is somebody who's disabled. They are non-EEA national adults dependent on the person who's British citizen or a settled person in the UK. Fourth category is somebody who requires long-term personal care to be provided. Now, this often happens, these types of categories often happen when somebody perhaps gets married from abroad and moves over here to the UK to join their wife or their husband, and they leave behind their parents. It might be their parents, might be their grandparents, might be even an auntie or uncle, and those people have nobody to look after them, right? Because their child or family member is moved abroad, and whereas normally, as part of their cultural norms, they would be looked after by them, there's nobody left for them, right? And they're on their own. One of the most oft-repeated applications we come across is people who want to bring over their parents, who are elderly now. They've got married and moved to the UK, and their parents are still back home, and they're very worried about them, they're very concerned about them, and they're in a dilemma. They can't leave their new life in the UK and their children and their spouse to move back to where they've come from. But at the same time, they're concerned about leaving their elderly parents or even their grandparents and not giving them the opportunity to look after them. You know, certainly from many religious perspectives, it's considered an extremely high virtue to be looking after people who are elderly and people who are family members that are elderly. And so it's a really fantastic option that you have here, that you're able to exercise the right to apply and have those individuals join you in the UK so that you can act to care for them and meet their needs, especially if they are infirm and elderly. Now, obviously, these individuals wouldn't require an application to be made if they fell into a category that immigration rules didn't apply to, right? And we discussed this in the first program that we had on this subject 4 weeks ago. Individuals who have certain categories, for example, if you are a British citizen, immigration rules don't apply to you. But also, if you have a right to abode, not necessarily a British citizen, but you have a right to abode, then the immigration rules don't apply to you, right? So in the same sense, if you have a right, if that person who's living abroad has a right to abode, then they wouldn't need to put in an application to come and join the family member. The second category of people that we spoke about in the previous program was EEA nationals and their family members, right? They wouldn't need to meet any requirements of immigration rules. They're able to come here and not have to deal with that. As well as EEA nationals, we can extend that to their family members. So EEA nationals and their family members circumvent UK immigration rules. Another category of people that wouldn't need to put an application is somebody who's already got a settlement status. Pretty much stating the obvious, but some people do get confused about that. So let's look at the next issue here, we've discussed all the different types, generally speaking, of categories of family members that people generally tend to want to have them join the UK. But now I want to move on to the issue of entry clearance. If you remember from the first program that we did, we made a distinction between entry clearance, which is the process of applying for the visa from the external country. Then we spoke about leave to enter, which is the administrative process that takes place when you arrive at the airport. When you arrive at a port or an airport, you have to go through the administrative application of getting leave to enter. And then the final category is leave to remain. So let's go back to the beginning of those three categories of requirements. Entry clearance, and in this case we're going to be looking at the case of a partner who's wishing to come to the UK. And here, when I'm saying partner, let's define what that is, right? Because the immigration rules talk about partner, but we think different things when we hear that word. Well, the categories that are within the definition of partner include the following. Number one, a spouse, which is somebody who's got a valid marital relationship, right? Now you might think, well, what's the difference between a valid and an invalid marital relationship? The answer to that lies in the country in which the registration takes place, right? People could get married in a ceremony that is not legal. So when we say valid, it has to be a valid marriage. We're talking about in the legal sense. And when we talk about the legal sense, we're talking about the context in which the registration takes place. So whatever country they're in. Some people might think that they're married in a particular country and only later realize and discover that it's actually not a recognized registration. And so we always advise people to be wary and to be careful of the validity of that. The second category is civil partnerships. Now, civil partnerships don't exist in all countries. They only exist in some countries where it's recognized. Again, the same rule applies to civil partnership as with spouse, in that it must be a valid arrangement. It must be recognized legally. The third category, which we've talked about, is fiancé or a proposed civil partner. So this is the third category of individuals that are classified as partners. A spouse is classified as a partner, a civil partner is classified as a partner, and a fiancé or a proposed civil partner is also classified as a partner. Now, there are going to be people that don't fall into any of those three categories, right? Somebody who's not married, they're not in a civil partnership, and they are not married, and they don't intend to get married. But if you look at their arrangement, it looks almost identical to a marital relationship, and those are people that are cohabiting or living together. Well, the immigration rules very kindly also recognize them as falling into the category of a partner. And there is a requirement, though, there's more of a threshold to meet when it comes to people who are living together as compared to the previous categories, because obviously the spousal and civil partnership, you can easily document the existence of that relationship in a legal document. But people living together, although the immigration rules allow you to classify yourself as a partner for the purpose of the application, you need to do a lot more to demonstrate that in terms of documentation, and the arrangement has to be for at least a minimum of 2 years. You need to have been living together. I hope that all makes sense. So once we have understood what the definition of a partner is, you need to think, which one of those four do I fall into? We then move on to discuss the eligibility requirements of the application. And these are generally speaking four. The first category is the relationship requirement that you need to meet for the purpose of this application. The second eligibility requirement is financial requirements. The third is accommodation requirements, and the fourth is English requirements. So let's touch on these one by one. And one of the reasons why I wanted to define a partner for you for the purposes of the application process is because the relationship requirement varies depending on which category you're applying under. And so you need to be clear that for each of those four categories, whichever one you fall under, you need to have demonstrated how you belong to that category. So the first two, spouse and civil partner, you require a legal document. C, fiance, you need to demonstrate that with some indication of communication, meetings, paperwork, travel documents. D, very similar. If you've been living together, you're going to have some joint accounts, some record of your addresses and links to the addresses that you've been living together. So relationship requirements of the person who's sponsoring, the British person, settled person who's sponsoring, they need to be either British or settled and present in the UK. Right? So those are the two types of people that are going to be able to act as sponsors to facilitate one of the partner categories to come over. The second requirement with respect to relationship requirement is that you need to be over the age of 18 years. You need to be 18 and over. And the third relationship requirement is that you cannot be married to somebody within the prohibited degree definition of the Marriage Act 1949. Again, this is going to be stating the obvious, but we need to tick all the boxes, right? You can't be someone who's married to their mother or their daughter or their mother-in-law or grandchildren or sister or auntie or nieces, as an example. That's what we mean when we say prohibited degree categories. You can't have been married to somebody within those categories. Now, I'm pretty sure that's not going to apply to virtually anyone, but it's important to know that. The next thing, fourth category for the relationship requirement to be met, is that you have to have met the individual in person. Stands to reason, but you'll be surprised. Some people might meet somebody over the internet, or they might be speaking to them over the phone. They've never met them in person, but they want to get married to them, they want to put an application. Well, the relationship requirements of the application process requires that you've met the person, right? So if you're looking to bring somebody over as your fiance or a spouse or a partner, you really need to, a civil partner, you really need to have made arrangements to meet them. And if you haven't done so already and you want to consider doing this, you need to make that a priority on your timetabling. The fifth point of the relationship requirement is that the relationship has to be genuine and subsisting, right? So you might say, well, when is it not genuine? When is a relationship not genuine? Well, different categories of marriages can be not genuine, right? So you might have a situation where somebody's actually got married. They've got a documentation that can prove that they've had a marriage done, witnessed. It's all there, looks all legitimate. But the relationship requirement is that it has to be a genuine marriage. So it can't be a sham marriage. So getting married to someone and you've got some kind of financial arrangement that you pay them to get married to you for the purpose of the application, no, that's wrong. That's not classified as genuine. And therefore, you would and could be refused to be given permission to have this individual join you in the UK if it's a sham marriage. And there's criminal implications of that, which I don't really want to get into at this moment in time, but there are criminal implications to that. Then there's forced marriages, right? So somebody's taken abroad and forced to get married to so-and-so, and then they put an application in. The marriage certificate is all there and you know, is evidenced in a document, but it's a forced marriage. And if there's any indication that the arrangement is forced, then the application would be refused. The next situation where a marriage isn't genuine is the person doesn't have a capacity to consent, right? Maybe due to mental health problems or whatever health conditions impairs them from being able to provide consent. Although the name might be on the document, if they didn't have the capacity to consent, that's not considered genuine. Other examples of where immigration officials won't consider the relationship to be genuine might be where there's a reluctance on the part of the sponsor or the applicant to attend interviews. There might be some indication that other family members have been found to be forced into a marriage. There might be inconsistent accounts. There might be a lack of communication. So all kinds of issues arise around whether the relationship is genuine or not. And if it's not considered to be genuine, it's not considered to be subsisting, then your application has not met the relationship requirement, and it would and could be declined. Sixth requirement of relationship requirements is that it has to be a valid marriage. So all the details on the forms have to be correct and have to be recognised and acknowledged as being valid by the country in which it's taken place. Any previous relationships, this is point 8, any relationships that have existed before, they need to be evidenced that they have ceased to exist. So if you've been married before, you need to evidence that your marriage previously has ended. And the last one of the points that I want to mention is that you have the intention to live together as a spouse or a civil partnership, or continue to cohabit. Right. Moving on to the next point, financial requirements. So we've talked about relationship requirements. Now number 2 is financial requirement. The immigration rules require you to earn at least £18,600 for the sponsor in order to sponsor their spouse or civil partner to come over and join them. If you have children, the first child, you need to add on for the first child £3,800, and thereafter any additional children you need to add on £2,400. And there are different avenues available for circumventing that requirement when it comes to meeting financial requirement, including income from other sources and savings. But in any case, you have to provide documentary evidence of that. People can, as an alternative to employment, have sources from self-employment. They can have sources from pensions that they receive or maternity allowance. So we've talked about the relationship requirement. We've talked about the financial requirement. We're going to move on to the third category, which is accommodation. The sponsor needs to have suitable accommodation, which is not prone to being overcrowded if the applicant was to come and join them. And you'd be surprised what kind of places people get involved into. And the last requirement is the language requirement test. When you initially apply, you need to fulfill the A1 category. And when you want to apply for an extension, as of 1st of May 2017, you need to meet the A2 category. So that's been a general overview of requirements that you need to meet in order to bring over a partner. We've defined what a partner is. If you have any questions, feel free to WhatsApp us on 0788 55 786. My name is Shahid Hussain with Khan Solicitors, and I want to thank you for joining me this afternoon. And I hope that we've helped to clear up some issues. Hopefully I'll be joining you next week. In the meantime, during the week, you're welcome to send us any questions and queries. And have a nice afternoon. Thank you very much.
Locally at 103.1 on FM. Globally at imanfm.com.